Thank you, Mr. Speaker. I yield 7 minutes to the gentleman from the District of Columbia, Representative Norton.
Gentleman is recognized. Gentlewoman is recognized.
I thank the gentleman for yielding. I strongly oppose this undemocratic and paternalistic bill, which amends D.C. law. The over 700,000 D.C. residents, the majority of whom are black and brown, are capable and worthy of governing themselves. I ask unanimous consent to enter into the record letters opposing this bill from D.C. Mayor Muriel Bowser, the entire D.C. Council, and D.C. Attorney General Brian Schwab.
Without objection.
While Congress has authority to legislate on local D.C. matters, it does not have a duty to do so. It is a choice. In Federalist 43, James Madison said of D.C. residents, a municipal legislature for local purposes derived from their own suffrages will, of course, be allowed them. Since 1802, Congress has established various types of local government for D.C. In 1953, the Supreme Court held there is no constitutional barrier to the delegation by Congress to the District of Columbia of full legislative power. The local D.C. legislature, the council, has 13 members. If D.C. residents do not like how members vote, residents can vote them out of office or pass a ballot measure. That is called democracy. Congress has 535 voting members. None are elected by D.C. residents. If D.C. residents do not like how members vote on local D.C. matters, residents cannot vote them out of office or pass a ballot measure. That is the antithesis of democracy. The substance of this bill is irrelevant since there is never justification for Congress to legislate on local D.C. matters. Nevertheless, I will discuss it. I strongly oppose charging 14-year-olds as adults. However, whether to amend D.C. law to reduce or increase minimum age, a minor can be charged as an adult should be a decision for D.C. alone. In a series of cases involving 2005, the Supreme Court has recognized that children are constitutionally different from adults for purposes of sentencing. In these cases, the court noted that childhood is marked by rashness, proclivity for risk, and inability to assess consequences. The court said its decisions rested not only on common sense, but on what any parent knows, but on science and social science as well. This bill is not only cruel, but counterproductive too. Most incarcerated people return home. The evidence shows that a minor charged as an adult is more likely to reoffend and be violent after release than a minor charged as a juvenile. D.C. residents have all the obligations of American citizenship, including paying federal taxes, serving on juries, and registering with the Selective Service. Yet Congress denies them full local self-government and voting representation in Congress. The only solution to this undemocratic treatment is to grant D.C. statehood. I ask unanimous consent to enter into the record a letter explaining why D.C. statehood bill is constitutional from leading constitutional scholars, including Larry Tribe.
Without objection.
The D.C. statehood bill, H.R. 51, the Washington, D.C. Admission Act, grants D.C. residents full local self-government and voting representation in Congress. H.R. 51 reduces the size of the federal district from 68 square miles to 2 square miles, consisting of the White House, the Capitol, the Supreme Court, the National Mall, and remaining under the control of Congress. The new state consists of the residential and commercial areas of D.C. The new state has a larger population than 2 states, pays more federal taxes per capita than any state, and pays more total federal taxes than 21 states. I urge members to vote no on H.R. 5140. Keep their hands off D.C. and free D.C. I yield back.